So the Supreme Court looked at the amendment bill that was tabled by the government to change the provisions of the PTA. The Supreme Court took up the position that it can't look at the constitutionality of the PTA, which was passed in 1978, but can only look at the specific clauses the government is trying to amend. So the special determination of the Supreme Court shouldn't be taken as a license or an approval of the constitutional validity of the Prevention of Terrorism Act itself. It's important to remember that this act was passed in 1978 as an urgent bill, which means the Supreme Court only had 24 hours to go into all the clauses of the bill and determine the constitutional validity. And at that point, the government promised that the bill was going to be passed by a 2/3 majority. So all the Supreme Court had to decide at that point was whether the matter required a referendum or not. If you look at the amendments that the government has actually proposed, even these amendments don't go far enough in addressing the basic problems of the PTA. For example, the conditions on bail are quite stringent and are only operative in situations where a trial hasn't commenced after a period of 1 year. So it takes away the general right of bail that citizens have under the normal law of the country. If you look also at the detention period is reduced from 18 months to 12 months. Now this is executive detention, which means during this period under a detention order, a person can be held in custody without being produced before a magistrate on a periodic basis like with other laws in the country, and this is extremely problematic. Furthermore, even the amendment provisions of the PDA give broad immunity to public servants who act under the PTA for acts supposedly done in good faith. Again, this takes away the power of the judiciary to look into the acts of these public servants, and it creates this environment in which public servants acting under the PTA are insulated from prosecution and judicial review.